Welcome once again to Lehto's Law. Here's Steve Lehto.
I did the video shortly ago about ChatGPT and about how somebody is thinking about suing ChatGPT because some unkind things were said that were sourced back to ChatGPT. And I pointed out that for libel or slander, defamation claims, generally speaking, someone has to make a statement that is untrue, et cetera, et cetera. And the problem we have, of course, is that ChatGPT is not a person. So it would normally take a person to get involved in that transaction for there to be something actionable. I don't think ChatGPT has been set up to just sit there and spew things onto the internet by itself. People go in, give it prompts or ask it questions, and then it gives them an answer. So if they get that answer and then spread that answer elsewhere, then the person who got the information is spreading it. So my question that I raised rhetorically about the mayor who was threatening to sue ChatGPT for making claims about him that were provably false, the question I had was, well, who actually spread the claims? Did somebody ask it a question, get an answer, and then publicize this, or what? So Peter sent me a note and said, Steve, check out the terms and conditions that people agree to when they use ChatGPT, and then ask yourself as an attorney whether these are the terms and conditions that the average person ought to be signing. And of course, it depends on what you plan on doing, what you got from ChatGPT. So I actually pulled up two sections from OpenAI.com, which is the company that runs that. And I have the terms and conditions here of what they have you agree to when you use their service. And the first thing to talk about is actually the less sexy of the two, but it has to do with whether or not you can sue ChatGPT. If something happens that you think is actionable, well, you agree to the following mandatory arbitration and class action waiver provisions. Mandatory arbitration. You and OpenAI agree to resolve any past or present claims relating to these terms or our services through final and binding arbitration, except that you have the right to opt out of these arbitration terms and future changes to these terms by filling out this form within 30 days of agreeing to these arbitration terms or the relevant changes. So if you're using ChatGPT, unless you opt out of these terms, you're stuck with them. Likewise, they have an informal dispute resolution system they'd like you to use. The forum for the arbitration is a specific service that they name. They say each party will bear its own costs. They pay their costs, you pay your costs, unless it's determined that you cannot afford it, in which case the arbitration can make ChatGPT pay for the whole thing. And then there's a whole procedure here based, and then there's some exceptions. And so, for instance, if you file a small claims court action against them, they're not going to require you to arbitrate that. And then likewise, no class actions. Disputes must be brought on an individual basis only. Now, some people are going to say, Steve, you understand there's a trick. You can get around that no class action thing. Because there were companies out there that had said no class actions. So some smarty pants lawyer someplace got together with some app makers, and they created an app that would allow you to file a claim very, very quickly against a particular company that had that clause. And so many people got the app and filed claims that suddenly, instead of having no class action to deal with, the company had hundreds and hundreds, if not thousands and thousands, of individual claims against them, all generated by people using that app. So at G, they say mass filings. If at any time 30 or more similar demands for arbitration are asserted against OpenAI or related parties by the same or coordinated counsel or entities, ADR services will randomly assign sequential numbers to each of the mass filings. Claims numbered 1 through 10 will be disposed of, and it explains how they'll deal with that. And they've basically made it to where the advantage you'd normally get by burying them in litigation won't actually give you that big of an advantage. So I was surprised to see the mass filings subsection there because I'd not seen that anyplace else. I'm sure other people have used it. I'm not saying these people invented it. It's just the first time I've seen it actually laid out like that. But the real issue here for the average person is Section 7 of the agreement terms and conditions under OpenAI.com. Indemnification, disclaimer of warranties, limitations on liability. And yeah, I like to talk about warranties because that's what I do for a living as an attorney dealing with lemon law. Indemnity, though, is the scary part. You will defend, indemnify, and hold harmless us, our affiliates, and our personnel from and against any claims, losses, and expenses, including attorney fees, arising from or relating to your use of the services, including your content, products, or services that you develop or offer in connection with the services, and your breach of these terms or violation of applicable law. So let's suppose that you use ChatGPT and you create something, and then you publish it someplace, and somebody sues. Well, they sue ChatGPT because you ain't got any money. Well, they sue ChatGPT, and ChatGPT can then call you up and say, hey, we're being sued because of you. That Section 7 you agreed to at A says you will defend, indemnify, and hold us harmless. And you might say, but Steve, that's a bunch of word gibberish there. What's that mean? It means that they can hire attorneys. The attorneys can defend them, and they can then send you the bill, and you will pay said bill. And it doesn't mean that you will defend them. It doesn't mean that you're going to hire an attorney and then decide how much. No. They get to hire an attorney, and the attorneys then get to run their clocks defending ChatGPT and OpenAI, and then hand you the bill and say, here, there you go, pay us. It also means that if they get hit with a judgment, they can then hand the judgment to you and go, here, pay the judgment. And that's what all that means. So you will defend, indemnify, and hold harmless us, our affiliates, and our personnel from and against any claims, losses, and expenses, including attorney fees, arising from or relating to your use of the services, including your content. And notice it says arising from or relating to. So I've mentioned before, anybody can sue anybody. And so somebody could see something you published that you had generated through the ChatGPT, and they've just decided they don't like it. So they sue ChatGPT. And a court throws the case out, says this case has got no merit. Well, they still had to defend themselves, for which you will indemnify them. And it was a claim arising from or relating to your use of the services. So you got to defend them against that frivolous claim. And that's on you. And so it's a very scary concept. And I can tell you right now, I actually had a case once where my client and I went into court to a settlement conference with one of the big three automakers. We had this unusual case where the manufacturer was on the hook and the dealership was on the hook for a separate problem. And I honestly believe these two problems were completely separate and unrelated to each other. So when we went to court, talked to the attorney from the manufacturer and said, we want to settle this case between us. We'll deal with the dealership later. And the manufacturer said, great. The attorney did. And so we put a settlement on the record. As we were walking out, the attorney for the manufacturer turned to me and said, will you indemnify us against claims brought by the dealership? I go, of course not. She goes, I thought we agreed to that. I said, we just put a settlement on the record. Did you hear the word indemnify come out of anybody's mouth? And she actually dragged us back into court and said, Your Honor, we forgot to put something on the record. I said, no, we didn't. And the judge goes, well, you guys put a settlement on the record, and the court rule says that once you put it on the record, it's final, unless you both agree it was a mistake. I said, no, Your Honor, she came up with this idea about us indemnifying them after we were walking out. We had the discussion in the hallway. And I think the attorney had screwed up and spoken to her client, and the client was the rep from the manufacturer. I think that the rep had actually told the attorney, and be sure to get them to indemnify us. And I told my client, and I also told the court, I go, never in a million years would I have my client agree to indemnify General Motors against an action by one of their dealers who's upset that GM left them hanging out to dry because our lawsuit, after we settled with the manufacturer, was going to continue against the dealership. And it did, by the way. And because of that, we got a very good settlement out of the dealership. And if the dealership had known that they could sue GM, and then they'd be running up our fees, not just for me prosecuting the case, but me and my client paying to defend it over here, we would have wanted to settle that case real fast. And so it's always a dangerous concept where you tell somebody, yes, I'll indemnify you, or I'll pay these bills in the future, and we don't know how big they are yet. And legal fees have a way of getting out of control. When you agree to indemnify, defend, and hold harmless OpenAI and ChatGPT for any claims, losses, or expenses, including attorney fees, arising from or relating to your use of these services, that could get ugly. Now, what are the odds of it happening to you? Pretty slim, but it could happen. Disclaimer, you should know that the services are provided as is, except to the extent prohibited by law. I'm not sure if there's actually a law out there that says a service such as ChatGPT cannot provide those services as is. But you never know. It says, we and our affiliates and licensors make no warranties, express, implied, statutory, or otherwise, with respect to the services, and disclaim all warranties, including but not limited to warranties of merchantability, fitness for a particular purpose, satisfactory quality, non-infringement, and quiet enjoyment, and any warranties arising out of any course of dealing or trade usage. We do not warrant that the services will be uninterrupted, accurate, or error-free, or that any content will be secure or not lost or altered. And notice the word accurate buried in that paragraph. They do not warrant or guarantee that their services will be accurate. So it gets back to somebody asks ChatGPT a question, it gives them an answer, which if broadcast or published becomes defamatory, well, then guess what? That's not on ChatGPT or OpenAI because they specifically disclaim the warranty, saying that their product will be accurate. Also, you should know that when they disclaim the warranties of merchantability or fitness for a particular purpose, those two warranties are the two that in the UCC specifically say must be disclaimed in writing or in some conspicuous manner. And they're going to say that this right here in Section 7 does qualify for that. And most courts would probably say that because it is in all caps. So trust me, it's there. And then finally, you should know that neither we nor any of our affiliates or licensors will be liable for any indirect, incidental, special, consequential, or exemplary damages, including damages for loss of profits, goodwill, use or data or other losses. Even if we have been advised of the possibility of such damages, our aggregate liability under these terms shall not exceed the greater of the amount you paid for the service, which of course is generally free, that gave rise to the claim during the 12 months before the liability arose, or $100. The limitations in this section apply only to the maximum extent permitted by applicable law. You are agreeing to that. So you have to ask yourself, what kinds of liability could arise from this service? And the obvious one we've discussed several times, and that is that you could ask it to describe somebody or person. It could make a statement about that person, and then you might publish that statement, not realizing it contains falsehoods that are injurious to the party described. And that person could come back and say, we want to sue you, and we want to sue ChatGPT for having originated that statement. Well, but you published it. But the point is that they'll probably sue both of you. Number one, when they sue OpenAI, OpenAI is going to hand you the bill and say, defend us. And then they're going to sue you, and you're going to want to say, well, I didn't actually craft that. They did. Well, they specifically say that what they write is not guaranteed to be accurate or error-free. So you can't really use that as your claim against them. The other thing that occurred to me is that let's suppose you went into ChatGPT and said, tell me about Douglas Houghton. Tell me about Douglas Houghton. I'm making this up, by the way. But I did write a book about Douglas Houghton. And let's suppose, and I don't know if there's any possibility this is real, but let's suppose that the people who created ChatGPT at one point or another scanned in my entire book on Douglas Houghton. And so let's suppose that you said, tell me about Douglas Houghton's childhood. And let's suppose that ChatGPT was really, really lazy one morning. It had a rough night. It was drinking virtual coffee all morning. It ain't helping. And so ChatGPT says, you know something? Let me tell you about Douglas Houghton. And it simply cut a big section out of my book verbatim and just handed it to you and said, there you go. That's Douglas Houghton. Get out of here. And so you go, oh, here's ChatGPT writing something about Douglas Houghton. And you skim it, and it seems realistic and true. And so you publish it. And for some odd reason, I'm poking around one day on the internet, and I see this big, huge passage from my book, verbatim, not credited to me. I might get upset by that Now, whether I'd sue somebody, I don't know. But my point is that if I came after you and said, hey, you've got a big passage of my book here that's not credited to me, verbatim, word for word, taken from my book, I think that's inappropriate. You cannot turn around and say to ChatGPT, hey, you did me wrong here because you took some material belonging to somebody else, just plagiarized it. Well, they never actually said that they wouldn't do that because one of the things they disclaim is there's no satisfactory quality and there's no guarantee of non-infringement. And so the argument I'd be making is you're infringing on my copyright. And they never said they wouldn't. And you agreed to that at 7B. So Section 7 has 3 sections. One is the indemnification agreement that you'll defend them, including pay their attorney fees and any harm that befalls them. 2 is the disclaimer, there's no warranties or anything like that. And then 3 is the limitation on liability. The most they'll ever pay to anybody is $100 basically. So that is the language in the OpenAI.com agreement for ChatGPT at sections 7, and I believe it's 8 is the legal section. You should at least be cognizant of those and just aware of them and deal with it as you wish. But Peter, thanks for sending it to me, and you can look that up yourself at OpenAI.com. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Instruction does much, but encouragement, everything.